For the second time in recent months, the Supreme Court decided not to weigh in on the Trump administration's decision to end the Deferred Action for Childhood Arrivals program. Known as DACA, the Obama-era immigration policy protects some young undocumented immigrants brought to the United States illegally by their parents from deportation. Bruce Miller is a law professor at Western New England University who specializes in federal courts. I asked Miller for his reaction to the court's inaction.
It wasn't surprising to me because the government had asked for something fairly extraordinary, which was for the court to review a decision of a federal district court, the lowest federal court, before the appeals court that normally would sit over it had had a chance to decide it yet.
It's so unusual for our government to get in the way of that sort of normal process?
Unusual for our federal government, our executive branch, to jump the gun that way. And it's done rarely, and it's allowed even more rarely. So the fact that they didn't act is not surprising.
Why, in your opinion, was the Trump administration trying to sort of circumvent what is the normal process?
Two reasons. Number one, get to the Supreme Court always as quickly as you can to take advantage of the 5 votes you think you have there. That's probably the biggest
the 5
thing.
conservative votes.
That's right.
The Trump administration was probably hedging its bet, thinking they're going to vote in my favor.
They believe that they've got 5 votes, yes. The second reason is that the Ninth Circuit is reputed to be, I think accurately, the most liberal circuit in the country. To be able to skip them and not have whatever force an opinion from the Ninth Circuit might have in the way between the decision that they were seeking review of and the Supreme Court, I think they thought was to their strategic advantage.
And so at this point, the court has decided for the second time, the Supreme Court has decided for the second time not to take action.
Not to take action. They didn't act one way or the other on the petition for certiorari. They still could, but they haven't.
And how common or uncommon is it for the Supreme Court to kind of kick the can in that way?
The Supreme Court denies review a lot. Their control of their docket is almost completely their own. And they do it frequently, and they do it for reasons that we don't always understand. Sometimes it's as simple as 4 who think they might want to take the case, and it only takes 4 to take it. Mm-hmm. Realizing that if they do, they might lose because the other 5, they predict, would not go their way. So sometimes you'll see the court, for example, there was a case involving Planned Parenthood where I think most people expected the defunding of Planned Parenthood to be something the court would be interested in reviewing. Justice Kavanaugh joined Chief Justice Roberts and the liberals in deciding not to review it, to the outrage of the other 3 conservatives. And that could have been a matter of vote counting. Another reason, and of course the court would be silent about this, is they hope for a political resolution of the matter. And they think that maybe if they defer it, there'll be one. And that could be true with the DACA question.
And when it comes to DACA, what does this now mean? The fact that the court has now twice said, we're not going to weigh in yet.
Yep.
What does this mean for those 700,000 or so folks who are kind of in limbo?
It means that for the moment, they are safe. Because what we've got is a decision from two injunctions from lower courts that stop the Trump administration from altering the DACA program that was put in place by the Obama administration. Another interesting reason here why the court might be, in this particular case, the conservatives on the court might be seeking to avoid review, is that their reputation is for supporting a very, very broad grant of executive power in the Constitution. Came up in the Kavanaugh hearings. A couple of the justices might believe there are really no serious limits on executive power. The conservative justices, however, when President Obama was president, voted to stop a program very much like DACA. It was a program where President Obama decided not to deport the parents of DACA kids.
And that was temporary protective status?
That's not temporary protective status. It was called the DAPA program, Deferred Action on Parents. And the Supreme Court ended up dividing 4 to 4 on whether or not President Obama could do that. That had the effect of sustaining a decision of a court of appeals saying that he couldn't. But what's interesting to me is that the 4 justices who voted against President Obama are the 4 conservative justices who normally support a very broad grant of executive power.
Wow, that's fascinating.
And it was only not decided because Justice Scalia had died. I think the conservatives are not necessarily anxious to show their cards, that maybe they have a different view of executive power, depending on who the president is.
Let's remind people what exactly the court is taking a look at, because it's
Yes.
not the legality of the program, right?
Well, at this stage of the game, we're at a preliminary injunction stage. The district court has not decided the merits of the DACA program finally yet. All they have done is they've said that the Trump administration did not go through proper procedures, rendering their decision arbitrary and capricious.
Tug of war over the Trump administration's trying to leapfrog the normal process.
The Trump administration has tended to try to leapfrog many things, including an important statute called the Administrative Procedure Act.
What's the nitty-gritty of that?
The nitty-gritty of that is basically that when the government is going to change the rules, they have to allow the public an opportunity to have notice and comment on what they're doing. And they have to provide an administrative record that explains adequately why they're making the changes.
Because it would need to play out in a way that people could publicly comment, have enough time to do so.
That's right.
And so you saw the state of California and a few other states kind of jump in and say, hey.
You haven't done all of that.
Yep.
That's right.
Yep.
That's right. And all that's happened is a preliminary injunction, not a final judgment, from a federal district court.
And so in terms of this, prior to the temporary shutdown agreement that was reached now that gives kind of 3 weeks or so of breathing room here, President Trump had been extending DACA as kind of a negotiating point.
Yes.
What happens to that now that the court hasn't done anything with it?
Carrie, your guess is as good as mine. I don't know what happens. I assume there will be discussion over the next 3 weeks about folding into whatever kind of budget agreement they might reach, some effort to protect the DACA people. But I couldn't possibly predict whether that will be successful, whether if it is, it'll be signed. I just don't know. I do think it will be under discussion in this 3-week period that we've got ahead of us.
And then from the court's perspective, when's the next time that they could take up this matter?
Their next meeting to decide whether they're going to take any more cases, and that's going to be in February. And since they didn't act on it, they could act then. But unless they did something exceptional, acting then would prompt the actual oral argument on the case to happen next term rather than this term, so that it probably wouldn't be decided by the Supreme Court until 2020.
So we're talking about several months before it would come before the court, and then quite a bit of time.
They could conceivably accept review in February and then set some kind of an expedited briefing schedule. But the fact that they had it in front of them in January and didn't do it, I think makes it very unlikely that they would, if they did accept it for February, then speed it up when they could have granted review in January. So I think if they do take the case in February, which could happen, they will set it down for argument next term rather than this term.